Ladies and gentlemen, thank you for attending today's webinar. Today's topic is privacy in healthcare, lessons learned from recent HHS OCR enforcement actions. Our presenters today are Attorney Eric Boughman, Attorney Charles Skip Sell. Eric and Skip, I hand it to you. Thank you.
All right, thank you, Tony, for that introduction. Good afternoon, everybody. Thank you for joining us today. We are back with what's going to be a new series that we're going to focus on over the next several months, maybe over the course of the year, because there's so much material here. And keeping with some of the other privacy work that we've done recently, it started off the year on December 31st with a comprehensive national privacy webinar, and we're going to cover some issues on privacy in healthcare. I'm happy to be joined today by Skip Sell. And Skip, you want to say hi to everybody?
Good morning. Eric. Knock, knock.
Who's there?
HIPAA.
HIPAA who?
Sorry, I can't talk about that.
All right. See, and you thought that this was going to be boring and dry with no humor. So I got a little chuckle out of that one already. And so with that, we're going to jump into today's material, and what we're going to talk about today is some recent enforcement actions. We're going to do a little bit of background on HIPAA enforcement and privacy enforcement in the healthcare context, which may not always involve strict HIPAA enforcement, and we'll talk about that in a little bit. But we're going to also jump into a couple specific cases. And as lawyers, and I know we have some lawyers that are on the seminar and we have some non-lawyers, and this is more for the benefit of the non-lawyers, the way we as lawyers figure out how to do things under a particular rule, statute, or regulation is to look at what people have done wrong in the past, look and see when courts, or in this case, we have one case from an administrative law judge, which is similar to it's a quasi-judicial body, similar to a court, and see how certain arguments have been made and certain rules have been interpreted, and try to get some takeaways from that and learn lessons on what to do and what not to do in the future when we advise our clients. If you have questions along the way, we'll try to address those. There's a lot in this area. If we can't address something, or if you think of something after the fact, we welcome your questions and welcome your comments and any follow-up after the seminar. You can reach Skip or I by email at my email address is bowman@forsterbowman.com, or Skip is at sell@forsterbowman.com. And also, we welcome you to reach out to us by email, phone, or connect with us on LinkedIn. So, as I said, we'll talk about HIPAA Enforcement Authority, who can enforce it, what the potential ramifications for violations are, and then a couple specific enforcement actions, and we'll conclude with some lessons learned and field any questions that you may have at the end. So, as an overview, HIPAA essentially provides a comprehensive set of rules for it's known as protecting health information, personal health information, or what's called protected health information, PHI, under the rules. But it's actually broader. It actually has a lot of statutory provisions that apply to insurance and other healthcare components outside of the privacy component. But we're talking about it, and where it really gets the most attention is in the privacy aspect. Privacy, data security, personal privacy is a huge hot button issue right now, worldwide and in the U.S., worldwide with the passage recently of the European Union General Data Protection Regulation, GDPR. At a national level, we have both the federal government, the FTC, and a couple of proposed national rules and statutes that have recently run through Congress, including one proposal by our Florida politician, Marco Rubio. There's also several state laws that affect privacy in general. California notably just passed a very comprehensive privacy law, and we'll probably do a seminar on that sometime in the near future. Reason being, a lot of people think, going off topic here, but it's actually, it all comes back to a big picture. A lot of people look at the California law and see that it goes into effect in the beginning of 2020. But what folks may not realize is it has a 12-month look-back period, and that look-back period puts us all the way back to January 1 of 2019. So if you're not in compliance now with that California rule, you need to be. Getting back to HIPAA, this is the body of rules and regulations, primarily composed of the privacy rule, which is a standards for protecting the privacy of protected health information, and the security rule, which discusses the specific regulatory safeguards to be put in place to protect that information. There's also a breach notification rule, and that includes a safe harbor if you encrypt certain information so that it's protected. The primary enforcement authority or primary enforcement agency for HIPAA is the Department of Health and Human Services. It was essentially assigned that task to its Office of Civil Rights, or OCR. And OCR is the organization that we're going to talk about today with respect to the specific actions that we'll cover. And often when you see HIPAA violations or HIPAA fines or resolution agreements, settlement agreements, which include corrective action plans that are usually part of some type of settlement or resolution, those are overseen and imposed by the Office of Civil Rights. OCR has the ability to bring legal action against, to conduct investigations and to bring legal actions against entities that are not in compliance with the HIPAA privacy and security rules. The primary mechanism for enforcement, as we note here on the slide, is through corrective action plans, or CAPs. And we'll discuss a couple of those and show you what those look like later today. OCR can also impose civil penalties, and oftentimes in connection with a resolution agreement, including both that we'll discuss today, there's a monetary component, and the rules outline specific standards for what criteria to use when implementing a plan that has a penalty or in imposing a penalty on an entity, including the willfulness of the violation. And then the corrective action plans usually are in the form of a comprehensive plan to ensure that violators are in compliance with HIPAA's requirements, and it has oftentimes an oversight and auditing component to it, sometimes a third-party auditing component. And I have a little statistic down here, interestingly. Since 2003, this comes from the Office of the HHS Office of Civil Rights, that since 2003, there have been over 55 HIPAA privacy rule cases that have resulted in fines being assessed over $80 million. And the ones we see today are actually big fines. They're all in the millions of dollars. So consistent with that, we're seeing that violations, especially if you're a large entity, can be extremely costly, and much more costly than just bringing in compliance to begin with. Also want to mention that OCR is not the only organization that you need to watch out for with respect to HIPAA compliance. The Federal Trade Commission has been active in the privacy realm generally, and often brings actions in connection with its enforcement authority under the FTC Act for unfair and deceptive trade or business practices. And FTC has brought multiple, and we're going to probably do one of our future discussions. We'll talk about FTC enforcement actions, but there's been recently 6 that I'm aware of, and maybe more. We're continuing to monitor that, and that's a totally separate animal. So the FTC can actually bring an enforcement action for HIPAA violations, and sometimes you'll see a situation where an entity or a party may say, well, we're not a covered entity, or we're not subject to HIPAA's requirements. and maybe that strictly is the case, but you can still get in trouble under the FTC rules if you, for instance, purport to protect information in compliance with HIPAA and don't do so. And we'll see, actually, that's an argument that was raised by MD Anderson in one of the cases we'll talk about today. One of the arguments that they raised is, well, we're not technically subject to HIPAA, so OCR can't fine us. But in those cases, the FTC can still come in and fine an organization for not being in compliance with its own policies and procedures. States attorney generals can, or attorneys general can, how do you say that, Skip? Is it attorneys general or attorney generals? I think it's attorneys general. Yeah. Okay, sorry, little sidetrack there. The states have enforcement authority under HIPAA, and California's been active in that regard, and I think we'll see other states as well, as again, as privacy becomes an issue in the forefront of a lot of individual concerns, and due to pressure on state legislatures and state government agencies, we're going to see more and more states attorneys general act if the FTC or if OCR does not act. And also, we don't have this up on the slide, but there's potential criminal penalties involved as well. And in one of the cases today, it actually stemmed from an investigation that began with the FBI. So whenever you're talking about criminal penalties, you're talking about state attorneys general, potentially U.S. attorney general, depending on what the nature of the violation is. So lots of different angles that you can get hit from here, and all the more reason to focus on what you need to do to be in compliance, or what your clients need to do to be in compliance.
Eric, before we go into some of the cases, one of the three rules that you talked about was the breach notification safe harbor if data is encrypted. And in the cases we're about to talk about, there were some devices that weren't encrypted. Can you explain to our audience what the safe harbor means? Sure.
So HIPAA doesn't specifically, there's provisions of HIPAA that do not specifically come out and say you need to encrypt. You have to protect the information. But there are standards that, if you follow the standards, can provide a safe harbor. And a safe harbor is essentially, if you do this, then, and you're following a certain procedure, even if there's a violation, you won't necessarily get in trouble. And so in the protection of protected health information, particularly electronic protected health information, or ePHI, while the HIPAA rules don't specifically require you to encrypt computers and devices, the rules are actually a little more flexible. The rules say you have to protect those from unauthorized disclosure, unauthorized access and unauthorized disclosure. But if you do encrypt, if you have an encrypted device, and that encrypted device or encrypted drive or computer is stolen, lost, or otherwise compromised, and you can show that it was encrypted, then even if there's a violation, then you still have an argument that, well, you've done everything you can. You've done everything reasonable to protect that, and you've encrypted it, and so potentially escaped liability for that. Good question. All right. Now, there's more in the rules about HIPAA penalties and the standards for assessing penalties, and you'll see that in the cases we look at, they're kind of, it sometimes seems like there's no rhyme or reason, because one violation that affects relatively few people may result in a fine, where another unauthorized disclosure violation affected many more people. In one of the cases, I think there's 2.2 million records that were disclosed. In another case, it was in the maybe 100,000 or less, and yet the penalty was higher in the 100,000 record case. But this is just a general overview of the categories of OCR enforcement, and you can see that that you go from Category 1 to Category 4 is more extreme. And I thought I had the penalty amounts in here, but if you're in Category 1, this is where you are. Oh gosh, I have a little slide thing. The Category 1 is where you are. Essentially, it's a mistake, and and it's the least severe of the violations. And when you go down to Category 4, Category 3 is willful neglect of HIPAA rules, where there's an attempt to correct the violation. Category 4 is a willful neglect of the HIPAA rules, where there's no attempt to correct the violation. And when you get into Category 4, the penalties become more severe. So you get to, I don't have it up there, but I had the penalty amounts. I'm going to give you those just so you get an idea, if I can pull them up pretty easily.
So it's a sliding scale.
It's a sliding scale, and so I know that Category 1 is $100 per violation to up to $50,000 per violation. Where you get to Category 4, that's where you get into the $50,000 per violation and up to what can actually be in the millions of dollars in penalties. And that's the kind of penalties that we'll see today.
When you're talking about violation, does a violation mean the breach of one device, for example, or does it also take into account how many individuals might be affected by being impacted?
Another good question. Both. It's the number of violations that are found. So, and that's subject to some interpretation. Here's actually the penalties. This slide, I have the penalties on here. So you go from $100 to $50,000 per violation for essentially what would just be a neglect to the more potent violations, which is $50,000 per violation for the willful neglect with no attempt to correct. So it goes by violations. Now, is the disclosure of one record on a computer one time considered one violation, or is it multiple violations? It's going to depend on the facts and circumstances of each case. But oftentimes what you end up seeing is you see several records that are disclosed in what are repeated violations, and that's the cases that we see. So you usually see, for instance, in one of the cases, there was several computers that were stolen or lost, and there was no control over the data whatsoever.
When you look at these categories, folks, the thing to bear in mind is that one factor that's being looked at is whether you are aware or should have been aware. But the second category that's being looked at is what you do to correct it. And if you make an attempt to correct it, that's better. You make no attempt to correct it, and then it gets very bad. You're talking about the difference between 10,000 to 50,000 per violation, and then going up to 50.
All right, so let's jump into one of the first case we're going to discuss. It involves Fresenius Medical Care, and Fresenius was hit for multiple violations, mostly related to its failure to secure and encrypt computers. And again, you don't necessarily have to encrypt, but encryption is the most secure way to protect data. Not only encrypting computers, but encrypting hard drives, thumb drives, mobile devices, and other mechanisms for data when it's in transport, not just resting on a computer. Do you want to give a little background?
I found this case to be fascinating because of the facts. So the healthcare company had 5 separate facilities, and these are the things that were taken. There was an unencrypted USB drive taken from a car. There was one laptop that was also unencrypted, taken from another car. There were 2 desktop computers that were stolen during a break-in at one of the facilities. And then at another facility, there were 3 desktops and 1 laptop stolen. And then at another facility, they misplaced a hard drive and couldn't find it. And so when they looked at these violations, they found about 521 names in ePHI were impacted. And the amount that they paid to settle was $3.5 million.
And it's also notable here, so under HIPAA, covered entities have a duty to self-report violations. So you should be keeping a log and reporting any security breaches or data breaches. Some of those might be minor and might not get much attention, but it's notable here that these were not submitted through a third-party complainant. This wasn't through a private or independent investigation. This was Fresenius self-reporting these breaches. And Skip makes a good point. The number of individuals affected is fairly low. But and we were talking about this before today's seminar. Why is the penalty? The penalty ended up being here, and Fresenius agreed to this. So it's notable that this is not part of a judicial decision or a decision of an administrative law judge, but this was a settlement agreement, a resolution agreement that Fresenius entered into with OCR related to these breaches. Perhaps part of it is that it relates to several different locations. So Fresenius had several subsidiaries, and so these breaches, you had breaches at multiple subsidiary companies. So desktop computers being stolen from during a break-in, unencrypted drives being stolen from a worker's car. Actually, there was one of them did involve an anonymous report of a hard drive being taken from a computer, and the computer actually had been taken out of service. So they took the computer, put it on the sideline, and the hard drive was stolen, but the hard drive was believed to have had ePHI on it. I think what an aggregating factor with respect to that hard drive is that the member whose hard drive was missing, once it was brought to their attention, reported it to the manager, but the manager failed to report that incident. How it ultimately, the agreement doesn't tell us how it ultimately came to the attention of OCR, whether it was actually submitted in a breach report to OCR, but I think it's notable in that case where the manager didn't do any follow-up. So again, if something comes to your attention, you need to take action. That puts us into that category 4 of the violations, where it's a neglect, and by not taking any corrective measures and not addressing it after the fact, it's going to throw you potentially into the most potent penalty mechanism. And there was a couple other ones where computers were stolen and set out of cars and from physical locations.
A couple of the findings that I thought were interesting on this case too was that they found that the entities failed to implement policies and procedures to address security incidents, and that they failed to administer policies and procedures to safeguard their facilities and equipment from unauthorized access, tampering, and theft. Not exactly what you think about when you're thinking about HIPAA and protecting information. This is protecting the devices that's protecting the information.
Yeah, and this argument's been tried. We're going to see this later in the next case we talk about. The argument that, well, we're not the wrongdoer here. Somebody stole this from it. They broke in and committed theft. So we're an innocent victim, just like the people whose information was stolen. But that argument fails, because if you're holding this data, if you're a covered entity, and again, I'm going to refer back. HIPAA follows. I'm going to digress a little bit here, but HIPAA follows general what are known as fair information practices that have come out of various multinational policies and foundations going back to the early 1970s U.S., the Privacy Act in the U.S. and most recently overseas, the European GDPR. Every privacy rule, regulation, policy puts the onus on the party who is holding or who is responsible for the information, the controller, or what in HIPAA is going to be the covered entity. That entity has responsibility for security. And if you use subcontractors, like in HIPAA, if you use business associates, you're responsible for your business associates. You're responsible for your employees and your agents. And if something happens and your information gets stolen, or if something else happens to cause a disclosure of information, it's really a strict liability standard in that sense. You are liable if the stuff that you control becomes disclosed or subject to disclosure wrongfully. So what happens here? So Fresenius has these violations. They enter into an agreement with with OCR. I think Skip's HIPAA joke threw me off in the beginning here. And they agree to pay a fine. Skip, how much was the fine?
$3.5 million.
$3.5 million. This is what they agreed to. And then they also entered into a comprehensive corrective action plan. We mentioned that earlier, a CAP plan, where they agreed to several security measures and under the oversight of OCR. There's also in the resolution agreement, if they don't follow these procedures under the CAP, then they could be subject to a larger penalty, and that's reserved in the resolution agreement. But if we look at the CAP, the plan, we can see here what OCR is concerned with. So it's a compliance plan. It basically goes for 2 years, and then they have to do a final report, assuming everything runs on schedule. And there's several components to it. So there's the first one is a risk analysis, and Fresenius has to conduct an analysis of potential security risks and vulnerabilities affecting the integrity, the confidentiality, and the availability of electronic protected health information. And they have to report that risk analysis to OCR. They have to develop a plan to manage the risk, and then that has to also be submitted to OCR and or HHS, and HHS has to approve that plan. There's a process under the plan by which they submit a plan. HHS can come back to them and say this is good, or we don't like the plan, you've got to revise it, and then that goes back and forth and continues in that process until HHS agrees with whatever the risk management plan is. Fresenius has to, and this goes for the Fresenius and all of its subsidiary entities, they have to develop a written process to regularly evaluate environmental and operational changes that affect the security of the electronic protected health information. So this is an evaluation process, and again, they submit this process and review process to HHS for approval, and HHS has the right to veto that plan and tell them to go back and change it or to accept it. And then once they have the risk management plan in place, and while they're doing the evaluation plan, they also have to develop an encryption report. And so that's another step. And the encryption report applies to desktop computers, laptop computers, tablets, mobile phones, USB drives, medical equipment that may be used to access, store, download, transmit protected health information. Any electronic data source that might have or potentially have or use electronic protected health information has to be included in the encryption report, and that encryption report has to identify the total number of what are referred to in the agreement as covered electronic media, and so each one of those devices is a separate device that needs to be accounted for in the encryption report. And then the report has to identify each covered media, and then identify whether there's a plan to encrypt the media, or if it's not going to be encrypted, there has to be a description of why the encryption is not reasonable and what the appropriate compensating safeguards will be. So again, as I noted earlier, you don't necessarily have to encrypt everything. You have to protect everything. Encryption is, at this point in this day and age, I think encryption is just the accepted mechanism for doing that. And really, that's what the encryption report is here. Is you have to either encrypt or explain why you're not encrypting. And then there's also policies and procedures for device and media controls. And this is both physical and technical security. So if you have, interestingly, I've seen facilities where all of the technical safeguards are done. So encryption, the computers are password protected, we're not sticking our password on our chair or on our desktop computer, so we remind ourselves when we walk in the morning, and then we walk away, and then we leave maybe a thumb drive that's not encrypted sitting on the desk where anybody can access it. Or we encrypt data and we encrypt it through any electronic communications, but we leave the computers in a place that they can be accessed without appropriate physical security. So security involves both facility access and access to those devices, and then the technological security around them. And then finally, the CAP calls for a training program that, again, HHS has to approve, and the training program has to properly train all of the employees of the covered entity who deal with ePHI on the proper safety protocols pertaining to that information. There's also another component to the plan where the policies and procedures and the training for the employees have to be certified both by the employees, and then an individual representative of the covered entity has to sign off that all the employees have been trained on the proper procedures and that the proper procedures have been implemented. And so somebody is going to be responsible for attesting and swearing that this plan is being followed, and that's going to be an officer or director of Fresenius in this case. And you usually see a similar provision like that in most of these CAPs. It may be a representative who's designated in the CAP or shortly after the CAP, a security representative, or it may be an officer or director of the company. And here it was an officer or director of Fresenius that has to sign off. And then they have to do annual reports to HHS. And the annual report has to include a copy of any training materials and a training schedule for the employees. Again, another signed attestation by an officer or director stating that the entities have maintained all electronic training certifications, and that all the persons who are accessing the information have been trained in accordance with the plan. And they also have to attest that that Fresenius was following the policies and procedures, and if there's any changes to those policies and procedures, those have to be identified for approval by HHS. And then finally, any reportable events. If there's anything else notable, any security incidents, they have to be reported, and the attesting officer is responsible for signing off on that as well. And there's a document retention policy, and then finally, again, if Fresenius does not comply, then there's another penalty component where HHS can issue a penalty against a monetary penalty. So if they agreed to pay $3.5 million, I have no idea what the penalty might be for violation of the cap. I guess we'll have to look into that and find one that's been violated, but they'd be subject to another monetary penalty.
Well, the hammer in these caps is that the entities and individuals are released under the action plan. But if there's a breach of the action plan, that release goes away. So anything they could have done, they can come back after you. And just so that you understand about the timing of how this works, I'm not going to go through all of it. Just to give you an idea, you have to go ahead and provide the risk analysis within 180 days after HHS approval of the methodology. Then within 90 days after HHS final approval of the risk analysis, then you have to do a risk management plan. Within 90 days after that's approved, you have to submit an evaluation process. The encryption report is due 180 days after the risk management plan is required. I just want to point out that it's a fairly lengthy process when you're going through it in order to get into compliance.
So that's a pretty comprehensive corrective action plan, and a lot of it is stuff that, really all of it is stuff that should have been implemented beforehand by Fresenius, and their failure to do so ended up costing them a significant amount of money. So the next case we're going to talk about is MD Anderson, and MD Anderson Cancer Center is a subsidiary of the University of Texas, and they got hit for a $4.3 million fine for failing to encrypt devices, laptops, and zip drives. This is a little different than the Fresenius case, because with the MD Anderson case, They did not reach an agreement. They challenged the OCR enforcement action, and this went to court before an administrative law judge. So it's a little bit different scenario than the Fresenius action. And Skip, you want to do a highlight of
Sure.
MD Anderson?
Well, there were three different breaches in this case. One was the theft of an unencrypted laptop, and that impacted about 30,000 individuals. The second one involved an unencrypted USB thumb drive that was lost, and that contained ePHI for about 2,200 individuals. The employee said that she had misplaced the drive on her way home from work, and it was actually an MD Anderson trainee. It wasn't even a full-time employee. The third breach was the loss of another unencrypted USB thumb drive that impacted about 3,500 people. And that's another one where the employee was driving home after Thanksgiving break, and when she returned to work, she couldn't find it.
And one of the things that that really hurt, I think, MD Anderson in this case, they made an argument that they were not subject to HIPAA's requirements. So this is where they had argued that we're not a person, a corporate person, subject to HIPAA. They argued it as a subsidiary of the University of Texas. They were not dealing with protected health information, but they were really just a research arm, and that they were not a covered entity. But they had written policies and procedures that they had published and updated going back to at least 2006, and this really hurt them, because one of the things the administrative law judge found is that even though they had written these policies and procedures and stated they were complying with them, they failed to do so. And so by failing to follow their own policies and procedures, they really buried themselves on the "we're not subject to HIPAA" argument. They opened themselves up to potential action, even if they had gotten away here by, as I noted earlier, the FTC has been hard on companies who make representations about their security and privacy practices and don't follow them. But the argument fell on deaf ears here. And I want to highlight a couple of things from the case. The administrative law judge says that it had although MD Anderson had established a policy requiring encryption and protection of devices containing ePHI, despite this awareness and its own policies, it made only a half-hearted and incomplete effort at encryption over the ensuing years. So while it was telling outsiders that it was encrypting data and information, or appeared from this opinion, that's what they were saying, they were actually, there were several devices that were identified as not being encrypted. And ultimately, this arose, by the way, from an FBI investigation, where the FBI had gotten information and turned it over to OCR, and an OCR's investigation led to this action. So here, the penalty ends up being $4.3 million. That MD Anderson gets hit with on a fine. And of course, OCR is going to have them in the headlights. They're now shown as being subject to HIPAA. There's a quote out here. I want to take one of these quotes and just read so you get a flavor for what this case was. I'll come back to it. Oh, this is the part I noted earlier. They had argued that, one, that they weren't a wrongdoer because they had been a victim of the theft of a stolen laptop, and even though the laptop wasn't encrypted, if the laptop hadn't been stolen, there would have never been a disclosure. They made another argument here that was it's kind of a little strange. They argued that the loss of unencrypted thumb drives and laptops was not a disclosure in violation of HIPAA because OCR could not prove that anybody had actually reviewed or read the information. In other words, even though we released it into, out of our control, you haven't proven that anybody actually accessed the information or read it. And so unless you can do that, it's not a violation. And they relied on a couple of cases early cases that really involved breaches of the Federal Privacy Act from the early 1970s. But the distinguishing feature in this case was that the Privacy Act cases involved damage claims. And so we see that here. So we'll get a call from somebody that'll say, well, my private information was disclosed or released, and I want to sue XYZ company. And the question that comes up is, well, okay, but did you suffer any damages? And we're seeing this in these data breach cases around the country. And unless you can show that somebody took that data or took that information and used it for improper purposes, and that you suffered some type of damages or loss from that, it's very tough to bring a private right of action because you don't have personal damages. But that's a civil suit. That's very distinct from a case here where we have a enforcement of regulations that are designed to protect information. And the judge handled that. The law judge, the administrative law judge in this case, handled that pretty easily, and he pointed that out. He said it's the private cause of action is distinct from a violation of HIPAA, here OCR doesn't have to prove that somebody actually reviewed the information. They just have to show that you released it out of your control. And that's where the judge also goes into a discussion of what the requirements are. And the requirements are to secure the information so that it doesn't come into control of another party. And the easiest way to do that is to encrypt it. And the judge, even in this case, points out that MD Anderson did not encrypt the data. They admitted that they didn't encrypt it, even though they were telling people that they were encrypting it. And that ultimately, I think, led to the downfall in this case. Anything else we want to cover from MD Anderson?
Yeah, I wanted to talk about the defense that they had raised about the regulations not specifically requiring that the devices be encrypted. When the judge was looking at that, what he pointed out was it was MD Anderson that chose to encrypt its devices because it wanted to address the high risk that it would lose the ePHI. And so the court decided once that MD Anderson embarked on that course, it was then obligated to either complete it or replace it with some other mechanism to protect the information, neither of which MD Anderson did. And so it was the persistent failure to carry out encryption that left this information naked and exposed to the risk of theft and loss. And the failure continued over a period of years, and he considered that an aggravating factor in determining what the penalties were. And he thought the penalties in the case were reasonable because of the gravity of MD Anderson's noncompliance and the number of individuals potentially affected. And this is how he finished the opinion. What is most striking about this case is that respondent, that's MD Anderson, knew for more than 5 years that his patient's ePHI was vulnerable to loss and theft, and yet it consistently failed to implement the very measures it had identified as being necessary to protect that information. Respondent's dilatory conduct is shocking, given the high risk to its patients resulting from unauthorized disclosure of ePHI, a risk that respondent not only recognized, but that it restated many times.
Yeah, it comes down to, again, making representations, identifying a risk, which they did, and once they identified the risk, making a representation that they were securing the risk, and then they failed to do it. And that's a good way to end, but I also like one of the other arguments that they raised and was quickly tossed aside by the administrative law judges. MD Anderson argued that the fine that OCR had imposed this $4.3 million fine was excessive and a violation of their constitutional rights under the 8th Amendment of the Constitution, which prohibits excessive penalties. And the administrative law judge just referred back to the guidelines for violations and said that basically whether those guidelines which he was following were outside of constitutional authority and violated the Eighth Amendment or beyond his decision-making authority. And so, and there it kind of it kind of brings the point that an administrative law judge has a lot of the powers of a regular judge in a court action, but is really sits in a quasi-judicial capacity. It's not like a normal court proceeding. It's more akin to an administrative proceeding before a regulatory body, like an arbitration or other regulatory enforcement actions. Although some of these cases can be sometimes appealed into the court, so you can challenge the actions of the ALJ by going into an appellate court in the federal court system. And we'll see. We'll probably talk about a case involving LabMD in a couple seminars from now. There was an FTC case with an interesting opinion.
Two other things to note before we go on to the next case. In this MD Anderson case, this was only the second summary judgment victory in OCR's history of HIPAA enforcement actions, and the $4.3 million is the fourth largest amount ever awarded to OCR by an administrative law judge or secured in a settlement for HIPAA violations. That was of June 18, 2018.
Again, and these are both recent. This is all three of these cases we talk about: MD Anderson, Fresenius, and then an excellent 21st Century Oncology are all recent cases that came out either very late 2017 or in 2018. And that's going to bounce us into our third case that we'll talk about here. Some overlap with the first one, but a couple distinguishing features to it. This is 21st Century Oncology. This was another enforcement action by OCR that resulted in a resolution agreement and a corrective action plan. And this involved a breach. It was significant. 2.2 million patients were affected. And what happened here is that this was an FBI investigation, and they were notified that patient information was illegally obtained by an unauthorized third party, and a third party had produced certain patient files that they had purchased to an FBI informant. And so the FBI informant informed the FBI, and this led to an investigation by OCR. As part of the internal investigation, once 21st Century was notified, they hired a third-party forensic auditing firm, and that firm determined that there may have been an attack and unauthorized access to its database. And this was sometime around 2015, where around 2.2 million records were disclosed. And what OCR, one of the issues here, and what makes this a little bit distinct from the other two cases, is this involves not necessarily a breach by the covered entity, but a breach by the business associate. And as I noted earlier, we talked about this, is if you are a covered entity under HIPAA and you outsource any of the control of the data, whether it's to another processor or for billing purposes or for any other purposes, law firms, accounting firms, etc., you need to have an agreement in place. And that business associate agreement is designed to essentially impose upon the business associate the same requirements to protect the information and safeguard the information as the covered entity has. And here in this 21st Century case, OCR found that 21st Century did not have written agreements in place with some of its associates, and did not have proper agreements in place, and did not monitor those the compliance with those agreements. So it ends up with a $2.3 million fine being levied against 21st Century Oncology. This was again part of the resolution agreement, and then there was a corrective action plan that requires, similar to the plan we saw with Fresenius, there's a risk analysis and a risk management plan, policies and procedures for safeguarding the technical and facility controls have to be implemented and approved by HHS. Distinct here, where the Fresenius plan focused a lot on the encryption reports. Here, the information HHS is concerned about was all of the business associates. So 21st Century had to submit to HHS an accounting of all of its business associates and provide copies of all of its business associate agreements, and then had to have a plan for monitoring and compliance with those agreements. There's also, again, similar to the Fresenius plan, attestation required, in this case by a designated individual under the plan. So instead of it being a corporate officer or director, in the CAP for 21st Century, there was a designated compliance representative that had to sign off on everything, and annual reporting requirements under the plan. Skip, what do we learn from that, or what else would you point out unique about 21st Century?
I think this is another one that is a little different, but it deals with the fact that the information is not properly protected. I mean, with the first one, they were being taken out of cars and stolen from entities. This one, you've got a business associate who was unauthorized. And so there's different ways that these pieces of information can be vulnerable. So you've got to be thinking big picture about protection.
And one other, that's a good point, that not only, again, and we've seen this, not only is it is a protection of the information that's within your control, but all of the other parties, whether they're employees. We've seen the issue where employees take devices home or are accessing information from computers that are outside the physical control of the entity, the covered entity under HIPAA. We've seen in the MD Anderson case, one of the individuals was a researcher who wasn't an employee and actually just come in to do some research, and that person had accidentally lost, apparently copied some information onto an unencrypted thumb drive and lost it. But again, MD Anderson was responsible for that. And as you point out, Skip, if you have business associates that aren't protecting the information, you're still going to be held responsible. And that's, again, we're seeing this through a wide spectrum. That was the case with Equifax. A lot of folks know about the Equifax breach. The Equifax breach essentially came down to the failure, the breach, and the security failure associated with one of its associates. So it wasn't Equifax itself that got breached, but it was one of the subsidiary entities or one of its contract partners that it had actually designated to do processing work with regard to some of its data. I want to point out one other thing that we see often, and it's in this, and another distinguishing feature on this corrective action plan versus the Fresenius plan. Under the Fresenius plan, a lot of the work was done by Fresenius with the oversight of HHS. But in the plan with 21st Century, they were required to designate a third-party auditor, and we're seeing a lot of this activity where where OCR or the FTC has done this. They require parties to perform corrective actions, but they don't want to have to monitor it themselves. They just want reports, and so you're required to get a third-party auditing organization that you have to pay for, by the way, that's going to come in and write reports and make sure you're in compliance, and then that auditor is going to report back to OCR. And that's what was required here in the resolution agreement's corrective action plan with 21st Century. And with that, I'm looking to see if we have any questions. We've hit a little over 50 minutes. If you are an attorney and would like continuing legal education credit, please let us know, and we can. We don't have a course number for this, unfortunately, but you can still get credit, and we can help you get the credit for this. If you have any questions and we did not get a chance to get some today, I didn't see any pop up, but if you have questions after the fact and want to shoot an email to us, I appreciate hearing from anybody. And I want to thank Skip, kind of jumped into this last minute. Teresa and I were supposed to be on here, but Skip and I have done a couple other webinars together, and I thought it'd be useful to have somebody else knowledgeable. Skip's done a lot of work with hospital entities and is familiar with these issues, so it's good to have you join us, sir. And with that, and no questions, Skip, any final? You have another joke for us?
No.
All right. Okay, well, thank you again for joining us. Have a great rest of your day. And by the way, happy Valentine's Day. Don't forget your significant other. And in Norway, we celebrate this as Friendship Day, or not we, but they celebrate Friendship Day. So it doesn't have to be a Valentine. It can be just somebody you care about. Reach out and be nice to somebody, and we'll see you hopefully next month.